Yes! Hello, my beautiful friends. What an amazing day it is. Happy Thursday. I hope your week is coming to a nice, easy downhill close because tomorrow is a Friday. We're happy about that. But it's not Friday yet. We got business to attend to today and some good stuff that we're going to get into. We got some Supreme Court business. We've got Judge James Boasberg. We're going to be talking about him today because we're back at SCOTUS. President Trump and the DOJ submitted their final reply into the Supreme Court of the United States. Here's what it looks like. And we're going to go through it. It's a 21-pager. This is the battle over Tren de Aragua. The gangbanger ACLU lawyers came screeching into this case, told President Trump to turn the airplane around. The judge ordered them to get turned around. They did not get turned around. So we've got a bunch of stuff happening simultaneously. We've got Trump going to the Supreme Court to challenge the original stay, the original TRO, basically an injunction. They're asking for a stay of that, and they want an application to the Supreme Court saying, can you please help us, John Roberts, if you're not too busy. But we also had another hearing today discussing the order to show cause. Remember, we've explained that that's kind of like getting called to the principal's office when you're a lawyer. It's like, you are busted, bucko. So come on down here and explain why we shouldn't hold you in contempt and issue sanctions against you and your law firm. And Trump's DOJ had to go down there and do that today. So we have some reporting on this from several folks today. Kyle Cheney was listening in. We also had Margot Cleveland, who was listening in. And we got reaction from Julie Kelly, who was also there specifically inside the courtroom. So we'll see what she said about it. All comments on Judge Jeb Boasberg. Jeb! Exclamation point. All that is coming up. Then we're going to hear from Mike Lee, was on with Glenn Beck. And we'll hear from the president himself. Look at that nice new gold card, baby. It's only $5 million. I'm already a citizen, but I kind of want one because it just looks so cool. But we're going to need a lot more super chats for that. So anyways, we're going to talk about it. We've also got this story about this plane. Okay, so this judge, now we're finally in Texas. We're in the Southern District of Texas, and we're back in immigration court. And we've got this one person, Adrian Gil Rojas, a person who entered the country illegally, is also now filing a petition for habeas corpus, which is the proper filing in the proper venue. They did the right thing for once. And this judge is saying Trump violating this guy's rights, has to release him. And the administration not only has to release him in Texas, but they have to fly him back to New York. Now, I don't know if it's going to be a first class flight or what. I don't know if he's going to have to get upgraded or get the little towels and pat his face down. Beep, 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 beep. But he's getting a plane ride back to New York because they say they arrested him illegally and because the judges just love illegal aliens so much. So the judge we're going to talk about, who is the one behind this guy, is this guy, Judge Jose Rolando Olvera Jr. He's the one who is ordering this guy gets a plane ticket, maybe first class, I don't know, maybe private, I don't know. You know, multiple bags of peanuts, whatever he wants. Maybe even some Chardonnay if he's feeling dapper. But talking about that, we're going to learn who he is and more about that and get reaction from Bill Melugin because now the Democrats, they're going down to the border. I'm not kidding. We've been begging for them to go get a handle on it for 4 years while our country was being invaded and predatory incurred upon. And here Bill Melugin is reporting they're all going down now to the border. And Mark Wayne Mullen is going to talk about what we need to get passed in this next bill, which includes some border security and more. So all that's coming up. Then we're going to turn our attention to this judge, Beryl Howell. We remember that this case of Perkins Coie, which was Mark Elias's former law firm, Michael Sussman's too, when they were working together to try to collude to rig the 2016 election, when they sent Michael Sussman to go talk to the media and then go talk to the FBI and be like, we've got evidence of Trump collusion with Russia because Christopher Steele told us so. Idiots, liars, really. And they were with Perkins Coie. They're no longer with Perkins Coie, but Trump came out, of course, and said, we're not doing business with a hack law firm like this that hires a couple of losers. And Trump canceled all the contracts with Perkins. And so Perkins sued and said, you can't do this. Our constitutional rights. Right? And they threw a giant hissy fit. And of course, this whole case landed up in Beryl Howell's courtroom. And Beryl Howell, terrible. One of the worst out there in D.C. We'll explain who she is, of course, in case you forgot. But she heads this case, and she's been kind of split in this so far and not really been favorable to them because she realizes it's a contract dispute, right? Trump can cancel contracts. He doesn't have to do business with anybody he doesn't want to do business. It's his administration. So he doesn't have to do business with a law firm that went after and attacked him. But we'll come back on that. I got to calm myself down here. And all of that will be coming up. We're going to hear what Trump filed because they dropped in a motion to dismiss this entire case. And so we'll be waiting for Judge Beryl Howell to rule upon it. So all that is coming up, my friends. It is a beautiful Thursday. We had some tariff fallout conversations that we had this morning, and we're feeling quite good about it, quite frankly. Once you understand that we're going through a serious change and understand how the dynamics work with the 10-year treasury and the dollar and all the things, I think it makes total sense. We talked about it this morning. It was a great members-only stream. We'd love it if you became a member at watchingthewatchers.locals.com or on YouTube. Just click that join button. We do member-only streams in the morning. We'll be back tomorrow, 12 noon Eastern. It's morning for us over here. So we'll see you back then tomorrow. We'd love to have you come join us, watchingthewatchers.locals.com or on YouTube. Join up. We have an amazing community, ton of fun, great friends, and funny jokes as well. Not mine, theirs. All right, so we got business to attend to today now, my friends. Let's check it out and see where we are. Here we are. In the Supreme Court of the United States, President Trump submits his final reply in support of an application to vacate the lower level orders that came out from this guy, Judge James E. Boasberg, aka Jeb, and he's about as exciting as the last Jeb with the exclamation point, who was a big fan of guacamole or whatever. And Judge James Boasberg, as we know, has been a thorn in the Trump administration's side for quite some time, issued Trump an order to show cause to explain why he didn't turn the plane around after the Tren de Aragua gangbangers were on airplanes going down to El Salvador. Judge said, turn them around. Trump didn't do that. They landed them because they said that they were already outside of United States airspace and outside this judge's jurisdiction. And that the proper forum for them to complain about being illegally detained would be to file a petition for a writ of habeas corpus. And other illegals have done that. So it is a possible thing to do. But this judge also certified all of the gangbangers as a class of gangbangers. Wild. So you get those commercials like mesothelioma. Have you been injured by a mesothelioma or something? Call this law firm. Same here. Are you eliminating innocent American teenage girls? Well, great. ACLU would love to represent you. Give us a phone call. You're certified as a class, thanks to Judge James Boasberg, Washington, D.C. So we're in the Supreme Court right now, and a bunch of filings have come in. And the judge is ordered from the Supreme Court. We're here knocking on the door of Judge John Roberts, the Chief Justice there, who has been basically asleep other than when he wakes up ornery and has to lecture Trump about his co-equal branch of government powers and Congress's co-equal branch of government powers. But we're here, and now Trump submitted his final reply, right? So they're asking the court to hear the case and to vacate Boasberg's orders saying that Trump cannot deport these Tren de Aragua people based on his proclamation and based on the Alien Enemies Act. So they write, all right, listen, Supreme Court, John Roberts, we need you to do something about this, okay? A single district court called Boasberg has enjoined further national security operations pursuant to the Alien Enemies Act, which Congress passed that the president is using, that's two branches, to remove members of a designated foreign terrorist organization that is conducting irregular warfare against the territory in the United States at the direction of the Maduro regime that is housed in Venezuela. So a majority of the D.C. Circuit Court of Appeals acknowledged that this injunction is appealable and that it risks compromising delicate foreign negotiations over the terms and the conditions under which foreign countries will accept and detain these foreign terrorists. And this is the same position that Rubio has been arguing for some time. It took a lot of time to negotiate El Salvador to take these people. So when they're in the air, it's a complicated thing for the judge to say, well, just turn them around. Yet a separate majority declined to stay the district court's de facto nationwide injunction, because they're cowardly, which rests on a blatantly unlawful drive-by class certification. Drive-by, like a gangbanger. Perfect word. Drive-by class certification, just like a drive-by shooting. This judge loves the ACLU gangbang lawyers, so you understand what they're saying, Judge, right? They're using your language. Just if you don't understand, ask the gangbanger ACLU lawyers. This case is not about whether the TDA members who are subject to removal under the Alien Enemies Act get judicial review. Okay, they obviously do. Rather, as respondents acknowledge, the pressing issues right now are procedural issues about where and how detainees should challenge their designations as enemy aliens, right? In other words, if they want a judge to look at this, it's very easy for them to do it so. All they have to do is petition for habeas corpus. It is a modality that is well fleshed out in the law, and you do it where you're being detained in Texas. In fact, in our next segment, we're talking about a case that is exactly that. And it's strange how that illegal alien was able to go find a lawyer and file this writ, but everyone else can't do it. So this judge is so worried about the gangbangers that he has to certify them as a class, lest they be dispossessed of some legal rights. They can hire lawyers. It's very clear. We're going to cover it next. But they say those issues are now calling for this court's resolution right now. They're interfering with our operations. Otherwise, the wrong court, which is DC, is deciding the wrong issues, which is our APA claims. These are not APA claims. These are habeas claims. They're also doing it through the wrong device, which is a grossly improper class action. And we're not underselling this. There is a certified class of Tren de Aragua gang members certified by Judge Boasberg from Washington, D.C. It's not an understatement. He certified them. Anybody subject to the proclamation is now covered by this nationwide injunction. Who is the proclamation directed to? Tren de Aragua. Literally, they're certified as a class. While the wrong remedy remains in place, which is a nationwide class-wide injunction. So you're like wrong like 4 out of 4, Judge. Talk about the worst judge ever. Wow. If allowed to stand, those basic defects will require vacating whatever merits determination the district court ultimately makes. Okay. In other words, even if this goes forward and the judge thinks that this is appropriate, we're in the wrong place on the wrong claims. The remedy is wrong. It's all bad. Now, in the meantime, by insisting on proceeding with these claims in DC, not the individual habeas proceedings in Texas, they are depriving Texas, the proper forum, of the chance to flesh out the scope of habeas and to start resolving individual challenges in an orderly way. The problem is, though, for them, if they go and they file under habeas, it's only individual. It's one at a time, one person, one lawyer, one illegal coming through, one after another. They can't just blanket stop Trump from executing the law. That's what they want. That's why they filed in D.C. By persisting with an unlawful class action that certifies the gang, respondents also inflict accumulating harms on absent class members who risk being stopped from pressing habeas claims by virtue of their being a part of this class action. That's interesting. Saying, okay, well, if now you are somebody who is housed in Texas and you would like to file a habeas claim, you can't, because you're now represented by these gangbangers in New York or wherever this DC. And so they are limiting what you can do because they have certified that you're part of their class. So go complain to them. They're suing there. You are precluded from bringing a similar claim. So respondents instead overwhelmingly focus. So these are the gangbang lawyers. They overwhelmingly focus on the merits of the Alien Enemies Act. Issues that were unresolved below and that this court need not even reach. So now they're saying, well, the AEA is kind of unconstitutional and challenging that. Now, despite their sensationalized account, the government's reading of the law is not one under which any religious or ethnic group could be summarily whisked away. They said, well, Trump could abuse the Alien Enemies Act and he could just go attack religions and ethnic groups and whisk them away to a brutal foreign prison. They're crying. to the Supreme Court. And Judge Sotomayor is just like crying. She's like, I need more Kleenex. This case involves a designated foreign terrorist organization, a designation that they don't even dispute, okay? Everybody knows who Tren de Aragua is. Not a mere criminal organization. The government Trump's position based on presidential findings, which you can't substitute your judgment for those. If the judge could substitute their judgment for Trump's findings, the judge is the president. They can't do that. Is that TDA is effectively an arm of Maduro. Okay, it's not a run-of-the-mill criminal gang. And so the Trump proclamation is not based on this quote from them, a migration equals invasion theory. That's not what he's saying, even though that's true, but on the finding that TDA specifically is conducting irregular warfare, they're undertaking hostile actions against the United States. They're committing brutal crimes, they're trying to destabilize the country, and they're terrorizing our citizens. And Trump and the government acknowledge that the 5 named plaintiffs in this lawsuit, not the class that the judge certified for everybody, all 5 of them would have ample opportunity to challenge their designations. If they say, we're not gangbang Tren de Aragua folks, they can just file a habeas petition in Texas instead of certifying this as a class action in Washington. They can sue back in Texas. Now, finally, it should go without saying that the United States' position is to abhor torture, okay? We don't want torture. We don't invite brutalization. The United States has ensured that removed aliens would not be tortured and never would remove any alien to El Salvador if it believed that doing so would violate the obligation under the Convention Against Torture. And moreover, Congress expressly recognized that the executive branch could and would remove aliens to third countries, so such removals are hardly novel or presumptively suspect. And by the way, like if Venezuela wants to take these people back, right? My understanding is they're not taking them back. If Venezuela wants to go take them and deal with them, take them. But they won't. If Venezuela wants to give their folks due process, well, they can go ahead and go back to their homeland and, they can self-deport, get out of the country, and they can go deal with things back home. Otherwise, it's, from our perspective, they're not affording us due process to the American citizens or to the nation when they break and enter and they commit crimes as part of a gang and as part of a predatory incursion into our nation. If they're so upset about it, go complain to Maduro, all right? Respondents and their allegations on this score exemplify the broader problem here. Judge Boasberg at the low court, in its haste to stop sensitive national security removals, rushed to judgment in advance of the evidence. This resulted in a pair of orders that destabilizes Trump's fundamental foreign powers and perversely hampers aliens from invoking the appropriate procedure, habeas, for challenging their designations. Go file in Texas. A single district court cannot broadly disable the president from discharging his fundamental duties, regardless of what you call the order, irrespective of its duration. And so this court, Supreme Court, should vacate this TRO, which is basically an injunction. Halt the tide of injunctions, John Roberts. Halt it. And restore the constitutional balance. They say, look, even though a majority of the D.C. Circuit Court of Appeals considered the court's orders to be appealable, they said it basically is an injunction. Because remember, the judges do the sneaky thing where they call it something that it isn't. They say, this is a TRO. We say, we can see your injunction. It's literally hanging out. Okay, we can see it. No, it's not. It's a TRO. I identify as a TRO. It's an injunction. We all know it. Even the D.C. Circuit Court with Boasberg was like, it's an injunction, dude. We can see it. It's like flopping all over the place. Says all 3 judges delved into it at merits. They still said that the orders are unappealable because all it did was preserve the status quo. Okay, so it basically is an injunction, but you still can't, ultimately, we're not going to reverse anything. That argument just shows how malleable the status quo moniker is and how unreliable a gauge it is for appealability. So status quo, what? They say, as the 2 Supreme Court of Appeals judges wrote, the challenged orders did not freeze the status quo. Boasberg didn't do that. They affirmatively interfered with ongoing, partially overseas national security operations. It was ordering the plane to turn around. Respondents deny, the ACLU gangbangers, that such interference occurred because the government can still detain and remove alien enemies under other authorities, and they may obtain relief through habeas, but the appealability cannot possibly turn on which party's views of the consequences prevails. And they say, look, Supreme Court, besides, Judge Boasberg's nationwide injunction, the TRO, it irreparably harms the government, not only by blocking removal of specific aliens, but also by halting the government's broader foreign policy plan to responding to infiltration by foreign terrorists and hostile regimes. Those irreparable harms show why we need review right now. You have to hear this. Now, conversely, their arguments from the ACLU lawyers and the Tren de Aragua class gangbangers, arguments regarding countervailing harms to aliens subject to proclamation do not weigh against their appealability. They actually support us. Now, the appealability is even clearer now. On Friday, Judge Boasberg granted the ACLU motion to extend the orders by 2 additional weeks, right? He says, oh, it's temporary. It's a temporary restraining order. Extended. Now, unless the Supreme Court intervenes, John Roberts, Amy Coney Barrett, the orders will be in place for at least 28 days. That's 1 month of our presidency that the American people had stolen from them. An intolerably long time for a court to block Trump's foreign policy and national security operations. Now, they downplay this. They say, oh, no, it's only 28 days. It's short. We just need time to figure it out, and suggest that any injunction subject to a finite time limit, like as long as there's an end date on it, it's unappealable. They say, no, you have to wait until it expires. You have to. But as the government has explained, barring an appeal of this, as long as they're subject to some time limit, is no real limiting principle at all. Under their theory, a notorious injunction against the bombing of Cambodia would have been unreviewable for weeks if it had simply been issued as 14 days and then extended. Somebody could say, oh, no, you can't bomb Cambodia during Vietnam. Sorry, you can't. I sued. Norm Eisen filed a lawsuit. I'm in charge. I'm commander-in-chief now. Okay, thanks, Norm. That's the logic. This Boasberg's like, yep, totally. I'm in charge. So we're going to win, they write. John Roberts, Amy Coney Barrett, you guys know this, and you're going to find this way sooner or later. So just do it now. Now, respondents must proceed in habeas. These Tren individuals have a claim. There is due process. There is a mechanism for them to appeal and see a judge on all of this. So every time they say Trump is just like throwing people out of airplanes, no, he's not. They're just not, filing these things. They could file it if they wanted to, as we're going to find out they do. Now, as the government has explained, there is a single, this is the law, exclusive path to judicial review under the AEA. It's called habeas, and it's filed in the district where they're detained. Now, they don't dispute this. They don't even disagree. They say, well, yeah, habeas court could adjudicate their claims, and that claims like this that are similar have historically been done like this. Nor do they offer any reason at all why they could not have filed their complaint in habeas in Texas. Well, we know why, because that's not what they want. They want a nationwide injunction. Now, after all, they initially styled the complaint as a petition for habeas corpus in the first place. And then the judge told them when they filed it, they filed all their claims like APA and Constitution, equal protection, habeas corpus. The judge he's like, hey, ixnay on the habeas A, okay? Because if you put that in there, then I'm going to have to dismiss this and send you over to Texas, which is the proper jurisdiction. And like, oh yeah, thanks, judge. Thanks for helping us cheat through the system and scam this. And then they refiled. Now, indeed, other AEA detained aliens have sought habeas relief in Texas. They do it all the time. Instead, though, they argue that habeas is not the exclusive cause of action. So because we're filing habeas, we also file other things. And so we're filing under the APA and more. Now, they are lacking in any merit in this crap argument. Their primary argument is that their challenge does not lie exclusively in habeas because it's not a core habeas claim. That's wrong. It's clearly a core habeas claim. Although they say they're challenging their removal, right? They're saying, no, we're not challenging their detention. We're challenging their removal. And this is clever, right? It's actually the transportation that we're upset about. Hold them in custody, just don't get them out of the country. Their claims attack the lawfulness of an authority. They say you don't have the authority under the Alien Enemies Act. In order to remove somebody, you have to detain them as the basis for the detention. Now, their claims are intrinsically calling into question the lawfulness of their confinement. Okay, can you move them around? Do you have exclusive authority to move this person and detain them where you need to? So in other words, they are literally habeas claims. They are core habeas claims about where the body is, the location. So you can't be, it's like removal, not detention. No. Now, because their suit inherently challenges the lawfulness of their detention, it meaningfully differs, they say, differs from claims that fall outside of the historical core of habeas. Going to give us a lot of details about why this is the right forum, or this is the right, habeas is the right claim. They say their claim is not habeas because they say they will remain in ICE custody, regardless of the outcome of this case, right? So ICE will detain them, but they just can't get them out of the country. But respondents challenge a basis for their detention and the one under which they are subject to imminent removal. And this argument just underscores the impropriety of a class certification. Other aliens in the class may be detained pursuant to only the AEA, and they're not all the same. So separately, they also fail because the APA, you can only bring claims that are final agency actions. Habeas fits the bill. All individuals agree that they may bring habeas claims, so they can do that, so they shouldn't be filing under the APA. Now, they barely engage with this point beyond brief contention that there is no alternative adequate remedy here. So we have to sue here because we can't sue anywhere else. They say, hello, for the fifth time. There is a process, okay? It's called habeas in Texas, for crying out loud. Respondents the ACLU says, well, even if this were adequate, they have no practical ability to seek this relief because they don't have proper notice. They say that's ridiculous. You clearly have notice. You're suing us right now. You had adequate time to bring habeas claims in their initial complaint. You put it in part of your original filing. So that shows you, Judge, they had the practical ability to bring a habeas complaint in Texas. Why can they sue in DC, but they can't sue in Texas? What's so different about the two forums? This office has been informed also that aliens that have been detained pursuant to the AEA are people who receive notice that that's why they're detained. They get notice. Oh, look, here's why you're detained. And there they can call a lawyer. Their family can call a lawyer, even if they cannot challenge the notice or itself attack removal as in a Title VIII proceeding. So then they also say, well, let's get around the APA. The APA says you have to funnel certain claims in certain directions. And they know that they attempt to distinguish some other cases which found that habeas was the exclusive remedy. They say, well, that case doesn't apply to us, so we can't file these other claims elsewhere. But respondents' ability to raise their challenges to their designation as aliens is and can be brought in habeas. So that means since there's another place where they can sue or file, they have to use that other place. They can't bring a claim under the APA. So they're just defeating their arguments one by one. Now, Supreme Court, John Roberts, Amy Coney Barrett, listen, at a minimum, this court should vacate Boasberg's universal relief. He certified a class of trend gangbangers. The district court, Judge Boasberg's vastly overbroad injunction offers a straightforward path to at least narrow the TRO. Black letter law requires courts to engage in a rigorous analysis before they certify any class, let alone a class of individuals who are subject to imminent removal as foreign terrorists associated with a hostile government. Now, had the Judge Boasberg actually applied the class certification rule, this class never would have passed muster. Now, the government has no objection to litigating individual habeas claims in the proper forum, one at a time. Come through and you can explain why you are not a gangbanger before we get rid of you. And if you can't do that, then you're gone. But you don't certify a whole class and just say they're all innocent after the president has made a determination based on other proceedings, on other evidence that they have. It's a co-equal branch of government that has the full legitimacy of the American people that voted in a popular vote for Trump. But district courts cannot bypass this. Otherwise, they could certify spurious classes, just like this, in virtually any suit challenging executive actions and create de facto nationwide injunctions without actually following the rules. And they offer no response to this problem. In quite the contrary, they actually try to bypass the rules, saying that it was their burden to show that this class of terrorists Tren de Aragua gangbangers should be certified. And they're not doing that. They say, well, actually there were exigent circumstances, and there's an exception to that because this was happening so quickly. They invoke some other case, but that wasn't a class action. That nobody can identify a single case here where an appellate court reversed a class certification exposes how far this certification of this class deviates from any traditional legal practice. If you allow this exigency circumstance Supreme Court to happen, it's going to become universal anytime someone seeks a TRO. Now they're talking about appeals and how the class certification plainly flunks the class rules. First of all, it's not an actual class of people. The variances are way too great. The class includes aliens who claim that they're not TDA members. They say, no, we're not. Actually, the people in this lawsuit claim that they're not TDA members, right? So how can the judge certify a class of people who say that they're not TDA members when the proclamation covers the TDA members? And the class consists of both aliens detained exclusively pursuant to the proclamation and other people who may be detained for other reasons. And habeas is the proper remedy. So they say the government misunderstood the rules and are pointing to other cases, but the variance here is way too broad. They say, well, everybody's seeking the same relief, but we're talking about the parties. The parties should be the people in the case, not members who are absent here. Now, in some Supreme Court, John Roberts, Amy Coney Barrett, if nothing else, the Supreme Court should vacate Judge Boasberg as to the class. Not only does that relief invite courts to impose universal injunctions, it's going to harm other class members. It's going to extinguish their claims, minimize their ability to file habeas. It's going to cause preclusive effect so they can't bring claims. And the lower court made major mistakes here. The ACLU and the Tren lawyers do not argue that the lower courts actually engaged in statutory inquiry. They just say the proclamation violates or they advance their own theory as to why this is a violation, but their own theory is failing on their own terms. Why? Well, they dismissed the TDA as a gang engaged in illegal migration, but they're ignoring Trump's determination that they're engaged in irregular warfare or hostile acts. They say, oh no, there is no invasion, right? Trump's proclamation is unlawful because we decide that there is no invasion. We decide that there is no predatory incursion. This is them substituting their judgment for President Trump's. That makes them the president. We don't give them that discretion. We'd never thought that they had the judgment to make that decision. Why should they have subsumed that now? They insist that those terms refer to military actions. Oh, okay, that's interesting. Well, then how come in the statute they didn't write military invasion or military incursion? Why does it say predatory incursion and not military actions? Why does it say that? Do you think the people who wrote that were morons? Maybe they do. And imminently led to or constitute acts of war. Well, why didn't they put that in the statute then? Dictionaries contemporary with the AEA's enactment refute that contention. Okay, it's a predatory incursion. As the government has explained, invasion was defined as a hostile entrance at the time of enactment. And dictionaries define incursion as an act of running in, an inroad, a ravage, right? It doesn't say military in there anywhere, nowhere. Alternatively, an incursion could be an attack, a mischievous occurrence, or an invasion without conquest by maybe like a non-uniform invasion force. That militaries and their branches were commonly perpetrators of incursions or invasions does not mean that incursions were inherently or necessarily militaristic operations. It was much broader than that. Now, even if their definition was correct, respondents ignored that Trump's determinations that their actions do amount to irregular warfare. Trump made that decision. So they asked this court then to find that their activities do not constitute war, saying, oh no, they're not at war with America. But whether activities constitute war is this kind of second guessing that you cannot do. The court refused to undertake that. Here, the court would be assuming functions of the political agencies if it judged for itself whether Trump was right to find that they were conducting irregular warfare. We didn't elect the judge to make that decision. The judge doesn't have all the facts. These plaintiffs don't have all the facts. Trump's in charge of the DOD and all of the executive agencies that make the determinations about what's happening in the country, not the judge. The judge can't substitute their decision for Trump. That's not how this works. That is a usurpation of power. Now, they also then say that the proclamation violates this because TDA is not a foreign government. It has to be a military from a foreign government. Otherwise, it's not a predatory incursion. Okay. Now, that argument ignores Trump's findings that TDA is intertwined with Maduro, by the way, to form a hybrid criminal state. Further found that TDA has infiltrated Maduro's regimes, his institutions, and has great control over it. Now, those findings are owed extraordinary deference. All right. You can't substitute your judgment, judge. But instead, the ACLU gangbang lawyers attack Trump's judgment. They say, well, the president's own intelligence agencies found that they were not controlled, that TDA was not controlled by Maduro, probably Politico or something. But respondents' own source reports internal disagreements about intelligence agencies, saying even the news that they're relying on is not conclusive. And why should that be dispositive over the president's full panoply of knowledge and information? Now, finally, respondents' assertion that the proclamation would transform this into a limitless source of power to deport any criminal gangs anytime is baseless. First of all, that's not how the government interprets the AEA. That's not what we think it says. Instead, it has invoked the statute under extraordinary circumstances to address this hybrid criminal state and irregular warfare that's being conducted against America. And so, Supreme Court, we need you to vacate this and put an end to this. They say the government's application raises numerous questions that are certification cert-worthy for you. And they don't argue otherwise. To the contrary, they characterize, they say, the ACLU lawyers, the stakes of this case as staggering. Gang members are going to be deported from America. They're all melting down. They write, Supreme Court, look, Judge Boasberg's orders cause the government ongoing irreparable harm in multiple ways. They threaten our ability to conduct foreign policy. They block the removal of dangerous gang members. Now, they say that that's not enough harm. It's too vague and speculative. But courts cannot second guess this. That is our representation. You don't get to say your judgment is better than ours. That makes you the president. Now, respondents then answer that removal of the gang members could be prevented through the habeas. They even admit. But habeas proceedings on this issue would be too individualized to proceed as a class action. That's not what they want. So while habeas proceedings could theoretically delay or prevent the removal of certain individuals, they would not result in a nationwide halt. So just go do that. Now, these are not mere technical venue disputes either. Okay, proceeding in an APA suit threatens the government's foreign relations when there are other things that they can rely on. We've got sensitive negotiations happening with El Salvador and more. And the government has explained the dangers of holding these TDA members in detention facilities. They have authorized their members to attack and kill U.S. law enforcement agents. Keeping them here would allow them to recruit new TDA members from within our homeland, and we would prefer that that not happen. Now, on the other side of the balance, vacating Boasberg does not cause them any harm. They say, respondents echo Judge Millett's concern. They say, well, that prison in El Salvador is pretty rough. But as a matter of foreign policy, however, the government would not remove any alien to El Salvador if it believed that doing so would violate the Convention Against Torture. El Salvador is in compliance with that. Moreover, the district court's order prevents removal to any country, not only El Salvador. So what if we find some other place? Can we ship them there? Congress has authorized the president to do this. There's a law. 8 U.S. Code 1231B2D and E say Trump can do this. The United States is currently engaged with other countries, and so we want to be able to send them there. Now, they say that they're going to suffer egregious harm because they wouldn't have had any opportunity to challenge this, to say, I'm just an innocent barber and father of 5 who just wants to grow vegetables to feed you Americans. They do have an opportunity. The government has explained they have a great opportunity to contest their designation. Just file a habeas petition, like they tried to do at the beginning of this lawsuit. Supreme Court, make them do it. For the foregoing reasons, the court should vacate Judge Boasberg and his injunctive orders, and do it quickly. Signed by Acting Solicitor General Sarah M. Harris, going up to the Supreme Court. So a very nice filing. We'll see what the Supreme Court does on that. Of course, we'll wait for the next steps from them and be back with the details. But on this case, there was another hearing that took place today. So while Trump was filing that to the Supreme Court of the United States, Judge Boasberg ordered a hearing to occur. And this was an order to show cause hearing. You see, this took place. We'll come back and explain what happened, but it's a show cause hearing. You're ordered to come into court and explain why you did the thing. Trump, the judge said, was ordered to turn the planes around in midair. Didn't do that. So the judge wants to know why. And we've got several people who listened in and one person who was there today who are reporting on what they heard from inside the proceedings. This is Kyle Cheney from Politico. He says, happening now, today in court, Judge Boasberg, this judge who we've seen make multiple orders against Trump to return terrorist gangbangers, he said he believes the Trump administration acted in bad faith on the day of the deportations. Boasberg says, my impression is that if you really believed everything you did that day was legal and would survive a court challenge, you wouldn't have operated the way you did, which I don't even know what that means. Everything they did was legal. That's why they did it. All right. He notes that Trump signed the proclamation on Friday, March 14th, but it wasn't made public until Saturday the 15th. Okay. Yet in the meantime, ICE teed up more than 100 purported Venezuelans for summary deportation well before it was made public. All right. So like they were stacking up their deportations to deliver a quick victory or something, which who cares? Like when it was announced, who cares when it was publicly announced? If those 100 purported Venezuelans or whomever was on the airplane, if they got notice about their deportation, that's all that matters. And they did, is what that filing just said to SCOTUS. They got notice. They did file. They filed here in D.C. Judge Boasberg, they had plenty of time. So they got notice. So I don't even know what this point means. That you were being sneaky with them. No, they knew they were being deported. That's why they filed the lawsuit before the proclamation even hit. So Boasberg began the hearing like this. Ticking through a set of undisputed facts, he says, with the Trump administration lawyer agreeing to each. Now, here's what the judge says. Now, this is this judge coping openly on the record. He's just coping. Because everybody's upset about this judge bringing back gangbangers into America, ordering them to turn around, right? Like the public, this is explaining how the public pressure is getting to these judges. They're people too, right? They're political, just like the rest of us. So he has to come out and clear the record on this. This is showing that it's stuck in his craw a bit. My TROs did not order any TDA member to be released from custody, right? Yes, Your Honor. Right? Yes, Your Honor. That's right. They didn't order that. And my TROs did not prevent the government from apprehending any TDA member, right? Right? Yes, Your Honor. Yes, Your Honor. And the TROs, he noted, also did not bar the administration from deporting any other TDA member through other well-established proceedings, right? This is the alternative source theory that we've had in other cases. Right? Right. Yes, Your Honor. In fact, we've been deporting people anyway. Okay. That's right. That's what I thought. So I don't love terrorists. I'm not a terrorist gangbanger lover, Rob. That's what he's saying. He's talking to us. And it's like, okay, Judge. Yeah, we know. Yes, you are. Yes, you are. You ordered them to come back to our country. Yes, you did. We saw you. Now, Boasberg, emphasizing, he says, it was just luck that I was available at 7:30 on a Saturday morning. I'm also getting criticized for why this case got assigned to me, since I'm getting assigned cases all the time. But it was just luck. I just happened to be up on Saturday, okay? So leave me alone. This case was filed at 1:12, and I just happened to be here, and I was like, oh, what's going on? So They filed it at 112, and I just got the case, okay? So stop harassing me. To block some of these deportations, he says, the rush was intended to avoid litigation, okay, and court scrutiny. He says the rush was, but he sounds like he is acknowledging, like, they did rush, like they were rushing very quickly. Maybe it was so it wouldn't look at it too aggressively, whatever. But also maybe Trump was rushing to avoid litigation, to avoid scrutiny, to like fly these people out quickly. So a lot was happening fast. Now, then he says that despite concerns that he raised at the early morning hearing and the fact that he scheduled a 5 p.m. hearing, he says, the government continued to race to put people on airplanes. He says, you knew that I was scheduling all these proceedings and you still were loading people up on the airplanes, knowing that I was going to issue a ruling. You were trying to have them take off before the court could rule. I know what you were trying to do. And he says, I want to talk about this person, Kilmar Abrego Garcia, who the government has admitted was on the third airplane, though not an Alien Enemies Act deportee erroneously, right? That was an administrative error. Like the dude should have been deported, but not on that specific plane, kind of a thing. And Trump admitted that. And again, you can determine what type of error that was, but they say actually he shouldn't have been there. He was an alternate, and there's some complexities around that. So he brings it back up. Now, Ensign, the DOJ lawyer, acknowledges. He says, Your Honor, members of my team at the DOJ were listening to everything when Judge Boasberg issued your order. He says, Your Honor, that's not true. We were here. We were doing everything you said to do on March 15th. And as soon as we were done, I communicated the order to the top lawyers at Homeland and the State Department. And I said, here's what the judge told you to do. And this is the real, like this, the bureaucratic delay execution strategy, right? You're going to move very quickly. You're going to move like so quickly. Yes, Your Honor, we're going to move fast. How fast? Like the government moves, like a bureaucracy. Oh, so we're going to send a pigeon carrier to say, oh, Judge, pigeon's going to try to catch up with the airplane and drop the note on the hull of the craft. And then they'll turn the plate around. That's how fast we're going to move, right? Just like the government normally does. So, Your Honor, we called and they... Now, Boasberg is saying, hey, who should I speak to if I want to hold contempt proceedings? Because I think you guys were trying to squeeze these people out of here. Now, I want to know who declined to give my order, the judge, to the pilots to turn the planes around, right? Gangbang lover judge who just wants these terrorists back, wants to know where did the game of telephone break? Or to keep the subjects of his order on the planes. Who is this? Well, the prosecutor says, Your Honor, well, maybe we should have a chance to submit more declarations from administrative officials to pinpoint that down for you. I don't know exactly who may give that order to whatever, but like I wasn't flying the airplane, so I don't know. I don't know who the pilot talked to, so maybe we can get more declarations from the pilot. Is that what you want to know? Judge says, well, I want to know whether any information the Trump administration says is covered by state secrets is classified. And Trump invoked the state secret privilege earlier. We covered this a week or two ago. Said, you're not getting any more information. The judge wanted to know when the plane take off, where did it land? Did it stop in any interim states? What kind of meal service did they have? Did they get the little warm towels before they landed for the terrorists? All the questions. Ensign says, well, I'm not aware that anything is classified. Well, if it's not classified, says the judge, then I don't know why I can't see this. If it's a state secret, then it should be classified. And you should give me this information. Well, Your Honor, we're not, it's the state secret, so our position is you can't have it. Well, the judge says, well, this is pretty sketchy looking, says Boasberg, that the DOJ won't even share information with me, the judge, in a classified facility and under seal. You're not even going to show it to me. No, Judge, you're not. It's not your branch. Get out. Happens all the time, he says. I get to see classified information all the time, so why won't you show it to me? Seems pretty sketchy. Ensign says it's going to have diplomatic consequences. Like what? Says Judge Boasberg. And Kyle Cheney, let's see if his reporting continues with more. Pretty sketchy looking. Now, we're going to turn our attention over to, thank you to Kyle Cheney for reporting those details. But now we've got Margot Cleveland, who is also listening into the hearing. She explains that the judge is looking into compliance with the TROs. The judge asked the DOJ to start. So we're rewinding again, just for a full picture. Says, Your Honor, given the public attention, I want to reiterate the effect of the TRO. Says again, you agree you did not release anyone to be released. You could have apprehended people. You could have deported them on alternative bases, right? My TRO only said you couldn't deport by Trump's proclamation. So he's kind of walking that back again. If anyone in the administration makes statements, they wouldn't be true. And the judge claims the government is acting in bad faith and didn't comply. So Margot has given us more details. Judge says, well, when was it signed? It was signed on March 14th, the proclamation. Well, why was it not made public right then? You don't think that that wasn't to get measures in place before it was possible to challenge it? I don't know, says the DOJ. You'd have to talk to the senior leaders. Well, the said president didn't even sign this order. Should I do anything about the statements? No, Your Honor, it's irrelevant. Well, at 3:53 is when the proclamation became made public, right? But ICE knew of the proclamation before it became public, right? I don't know, but I guess you could infer that since they were processing these people. Judge says, well, they say, the gangbangers, that the morning they were loaded on the morning of 3:15. They said that they were loaded before 3:53 and they were already working on it. So what other inference could you draw from this? Prosecutor or the government says, well, the only inference from this record is since it doesn't matter. Well, at 9:40 is when I issued the TRO for what was for individual 5. Trump government says, no idea, Your Honor, when it passed on, but we complied with your order. I learned about it sometime that morning. I think I learned like at 10:18. Said the Zoom hearing was at 4 p.m. Then it moved to 5 p.m. because you were going to certify the terrorist as a class action. So yeah, I knew about that. Judge says, is there any inference other than an expedited inference before the 5 p.m. hearing? No, Your Honor, there's no evidence that things were changed in any way. Judge says, well, they filed their lawsuit at 1:12 a.m. and I was available at 7:30. That's the only reason we were able to get relief before they were put on a plane. Judge, like, I just happened to be here. God, he's like racing in. Why when you knew I was having a hearing at 5 p.m. that related to class certification, the judge is saying, wouldn't a prudent thing be to say, well, let me slow down here. Let's see what the judge says. Margot says, Trump doesn't have to. Yeah, that's exactly right. Prosecutor says, well, I don't know the operational details. So I don't know, Your Honor, they were doing. Okay, so to avoid being enjoined by the court was to risk having people on a plane that shouldn't be, right? Including the one guy that you removed wrongly, right? Well, he was on a third plane, but you were rushing to get them out, weren't you? No, Your Honor, I disagree. There's no evidence that the third plane was rushed at all. And that third plane was not even pursuant to the proclamation. So no, it wasn't rushed. It had nothing to do with this. Judge says at 5 p.m., I asked point blank if any removal was planned in the next 24 to 48 hours. I asked you. And at 6 o'clock, you recessed and you couldn't give me any additional information. Are you now telling me you had no knowledge that the planes were in the air or shortly would be? Your Honor, no information from clients, and I tried diligently to get that information. And they told you nothing? Like you called Homeland, you said, hey, are they in the air? Well, Your Honor, that's attorney-client privilege, and so I'm not telling you. I'm not telling you what Homeland told me, so. All right, well, that's fine. Let me talk about that third plane, says the judge. And you agree if that removal was solely based on the proclamation, that plane took off after I issued my order. So that would be a violation, right? If you took that off on the yes, it would, Your Honor. If it was an error under Title 8, then it wouldn't be a violation. Okay, if we use Title 8, we can get rid of them. But at that point, yep, that third plane took off after your order. So that's why we didn't use your order. Are you saying everyone on that airplane, this judge going after him, are you saying everyone was El Salvadorian? Well, they're not so sure that it was kosher. What was the basis to remove these people who are not El Salvadorian? The DOC says, well, it's 8 U.S. code, whatever. It says we can remove people to third countries. That's what our authority is. And people returned to the U.S. Some women and a man was returned back. Operational that folks could be brought back. Was that part of the plan? I don't know, Your Honor. Were there other government officials listening on the hearing here? Well, I don't have a comprehensive list, Your Honor. Probably my team was. And on my team is this person, this person, and this person. I don't know if anyone else is here. The judge is saying, well, who else was on here? Well, my knowledge was that someone was listening by phone over here, and who else? And who else from the Trump administration was listening? I think James McHenry was on the phone, Your Honor. He's the associate AG, but I don't specifically know if anyone else was there. Well, I want to know who all was listening. Your Honor, that's attorney-client privilege. It's derived from the communications. No, it's not covered. You don't get to tell me who's not appearing in my courtroom. It's not covered, so I get to know. Whom did you tell about my oral order when I told you to turn those planes around? Whom did you tell? Your Honor, I relayed it to my homeland contact and to people at the State Department, and James Percival at DHS, and Joseph Bishop at the state, and others in the DOJ. In the written order that you sent, I gave it to the same people. But I had no intent to not have it go to the right people. Like I told them, this is what you ordered, but I wasn't flying the plane. So, well, who gave the order not to turn around? I want to know. Either not to tell the pilots or to keep going. Your Honor, that's attorney-client. And then says, I don't know. That's attorney-client privilege, and I don't know anyways. You don't know? Well, I don't know those operational details. Well, I'm interested in finding out. I want to see who is held in contempt here. So how do I get that information? Your Honor, I think it's better to decide based on the legal arguments. Okay, you don't need all the facts here. The law says we're in the clear. So if I find, for example, that there's probable cause, how should I decide who the contemptors are? Says the judge. And then additional briefing with declaration. And the judge says, if I find probable cause and I require a declaration, there's a good chance I'm going to have hearings on this. And if I find probable cause for contempt, would your client like the chance to purge the contempt? How would you purge this contempt other than returning these terrorists, these TDA gangbangers? Margot says, by the way, this is BS. Our president is not going to return these terrorists to our country. The judge says, I agree. I can find probable cause without seeing state secrets, but I want to understand what I am seeking, whether it's classified. Is it classified? No. Is the information classified? Well, I don't know if any aspects like that are classified. Can you point me to a single case where unclassified information is protected by state secrets doctrines? Your Honor, I'm not prepared to argue that issue. I have to look that up. It's not a live issue, Your Honor, because you have all the information you need. So I wasn't prepared to talk about that because you don't need it. Well, why not? Why not showing to me ex parte? Just show me the materials and I get to decide whether they're bad or not. We do that all the time in a SCIF. I look at top secret information all the time in FISA. FISA's not a good look, says Margot, yeah. And the DOJ says there would still need a showing of need, Your Honor. There is no need for this information. You've not shown us anything. You're just trying to hold us in contempt for some stupid reason. That's not a good enough reason. Well, anything to respond to the government? And any thoughts on contempt, gangbanger, ACLU lawyers? They say, Your Honor, we're finished with briefing here. I think the next step is some evidence that is sworn, declarations, hearings, depositions, drag all these people, drag Kristi Noem, drag the pilot in, drag everybody in here. We feel that your order was violated and we're willing to proceed with however you will prefer. The judge says, well, I'm going to review the material and issue an order on whether there is probable cause that contempt has occurred. And if so, whether contempt has occurred. Decision won't come until next week. That's the end of the hearing. So the judge sounds like he was not happy at all. And we saw a reaction from Julie Kelly. Julie Kelly was in there. Make sure you're giving her a follow, and Margot and everyone else who we talk about here. But Julie said, after quite the performance, Jeb Boasberg says he believes probable cause exists to initiate contempt proceedings against the Trump administration for disobeying his oral ruling to return the airplanes. He's on a massive power trip, shocking to watch, while Congress sits around and does nothing. So that happened today. So we'll see if the Trump administration gets held in contempt and if they're going to fight over removing terrorists, and in order to fix the contempt, they got to bring back the Trinidad Aragua gangbangers. wild that this is where they're hanging their hat. But here is the latest update. Says, yep, there was an order to show cause hearing. The judge took the matter under advisement, which means he's going to sit and mull it over for a bit before he comes back out and issues a ruling. And we'll see what he does then. But we've got people like Senator Mike Lee, who was on with Glenn Beck, talking about these judges, talking about what we can do about them. Now, impeachment has come up. Removal via House resolution has come up that wouldn't necessarily require the 2/3 impeachment threshold in the Senate. It's an argument that's being made by people like Andy Biggs, who submitted a resolution in the House of Representatives. But Congress could also defund them, could eliminate their jurisdictions, could just abolish the DC Circuit, since Congress sets the jurisdiction of the courts. So there's a lot of things that could be done. But John Roberts came out, was running his mouth about these judges, and I don't know if they're friends or what. I know that Kavanaugh went to Yale with Boasberg, and they were both in Skull and Bones together, and I think lived at the same house together at one point. But I don't know about John Roberts, but there's a lot of love there in that DC community. You know, they all go to the same cocktail parties and do the same things together. It's disgusting. But Mike Lee is saying, how dare John Roberts, a co-equal branch of government, try to shame us for using our powers in Congress or in the executive branch, which has a lot less with the judiciary, to govern their co-equal branches. John Roberts, if he got his house in order, wouldn't have to have the other government branches coming back and laying scorn upon him. Here's the senator explaining.
Yes, I think that's a fair way to put it, Glenn, but even more broadly, we can double down on the point, saying the country doesn't have to be metaphorically, in the position of the plane going into the large body of water before you can do that. This is a political function, a political decision to be made by a coordinate political branch of the U.S. government. Meaning this is, to us, what deciding whether or not to grant certiorari is to the Supreme Court. It is our decision. It is not that of the judicial branch. Now, sure, ordinarily, a bad ruling is dealt with by the aggrieved party or parties, appealing and seeking redress that way. I think that was part of what the Chief Justice was trying to say. But he went too far in suggesting, if this is what he meant, which it sounded to me like he did, if what he was suggesting is that and no more, you can appeal a judge you disagree with and nothing else, that's simply not true. That is literally not true. It's literally contrary to the text of the Constitution. And frankly, I think it's inappropriate for him to suggest what is and is not an appropriate time to use the impeachment power. That decision belongs to Congress.
Totally inappropriate for him to come out and lecture Trump about this, when if John Roberts just got his lower courts, his inferior courts in order, we wouldn't be having to deal with hundreds of lawsuits now with nationwide injunctions that are usurping the power from the executive branch. And if these Tren de Aragua gangbangers really want citizenship, well, they've made a lot of money. They should just go apply for a gold card. Now, obviously, they would not be granted a gold card. It's just a bad joke. But it is a nice card. I'm already a citizen, and I don't have $5 million for one, but it is a nice card. It would be fun to get one just for a memento.
$5 million. For $5 million, this could be yours. That was the first of the cards. And you know what that card is?
Gold card.
It's the gold card. The Trump card, gold card.
Who's the first buyer?
Me.
Who's the second?
I don't know, but I'm the first buyer. It'll be out in about less than 2 weeks, probably. Pretty exciting, right?
All right, so we're going to have to do a lot more live streaming and get a lot more super chats, but we're going to work on getting one of those right after we also get the Watcher Island. That's not going to be like the other islands. All right, so good stuff happening there. And we're going to keep our eye on Judge James Boasberg, the D.C. judge who was appointed by Obama, whose entire family is just filled with Democrats, who hangs out with Democrats, and who works very hard to pardon or to give probation to guys like Ray Epps and support terrorists being flown right back into our country. We're going to keep our eye on this one. Thanks for subscribing and joining as we do. All right, so we're not done yet. Let's talk about this other judge and another flight. So here's a very interesting one. Here it is, yes. A federal judge in Texas is now ordering an illegal to be flown, but not out of the country, back into the country, from Texas to his home in New York, not his home in his original country. Coming out of Texas, this is on a petition for a writ of habeas corpus saying that this guy was being wrongfully detained. The judge who's behind it is Judge Jose Rolando Olvera Jr., Southern District of Texas. And he was appointed by Barack Obama. Guy is 61, born in Texas, has no judicial experience before becoming a judge, was a partner at other law firms, and then became a political appointee. And he's now ordering that this person be flown back to New York. So there was a hearing, and Politico reported on what happened, said a judge in Texas has ordered the immediate release of a man who appears to have narrowly avoided being put on one of the last deportation flights going down to El Salvador. After a hearing yesterday in Brownsville, Texas, U.S. District Judge Rolando Olvera not only mandated the release of this person called Adrian Gil Rojas, we'll read some of the docs, but instructed the government to pay for his travel back to his New York City home. First class, probably. I don't know if he ordered the chicken or the steak, or maybe he wanted the vegetarian meal. But he's going to have a nice trip back home, no doubt. We'll read the order. Lawyers for Gil Rojas said he was arrested in New York in January, eventually moved to South Texas, was informed on March 14th he's going to be deported. But the aircraft had mechanical problems. The flight was rescheduled for the next day. Ugh! Within hours of the scuttled flight, Gil Rojas' attorney got Olvera to issue an order blocking the deportation. As a result, Gil was not on board when the last three flights took off on March 15th, proceeding to unload more than 100 Venezuelan deportees at the brutal San Salvador prison. And that's, of course, in El Salvador. So that's the update. Now, here's the backstory on this, because this was filed in the Southern District of Texas. So Adrian Gil Rojas, in the original complaint, filed a petition for a writ of habeas corpus, okay? This, by the way, is the right filing. If you're an illegal here and you think you're wrongly detained, or if you're not an illegal and you're detained, this is the right mechanism. File it in Texas, one at a time, go see judges. And several weeks ago, we said, just wait till we get to the immigration judges. Okay, we're not even there yet. Here we are. Now we're here, and they're doing exactly what we expected. So he wrote a petition for a writ of habeas corpus saying, I'm not a terrorist, don't deport me, all the things. And Trump and the DOJ responded. Here's what they said. All right, Judge, listen. We provide this brief reply in response to their motion for a TRO, or in other words, to stop the deportation of this person. They say Adrian Gil Rojas illegally entered this country on or about April 30th, 2023. Many thousands of people broke into the country illegally at that time because Joe Biden just let them run rampant. So then on May 16th, 2024, Mr. Rojas was granted TPS. Biden, again, granted temporary protected status to everybody on his way out. But his status will expire on April 2nd. That was yesterday from today. Mr. Rojas will not be able to extend his TPS authorization. Now, on September 10th, Mr. Rojas received a final order of removal in absentia, which means he did not show up for this proceeding to challenge his removal. Okay, got notice. This is what's going to happen to you. Was supposed to show up to a court hearing. Did not show up to court because why would they show up? Got a final order. You're out. Okay, you've got an order to get out of the country. So he saw a judge or didn't see a judge because he didn't show up. So then on January 21st, Trump came in. Guess what? He was arrested and detained like the next day. Okay. They move fast. Trump came in on January 20th. We had the inauguration and the watch party, and it was a ton of fun. Next day, dude's arrested. Thank you, Tom Homan. On March 11th, then the illegal filed a motion to reopen his final order of removal, right? The judge said, you got to go. You didn't show up to court. You're gone. It's a hearing in absentia. Bye. If you don't show up, you lose by default. You're gone. Well, I didn't know. He files a motion. I didn't know there was a court hearing at that date. I would have been there. I had a medical emergency. My kid, something was going on. Please reopen it. Then a motion for the TRO followed shortly thereafter, right? So he's like, oh crap, I'm getting deported. I got to go. So reopen everything. You should have gone to court, man. Now, Trump agrees that while Mr. Rojas maintains valid TPS status, and they submitted this on March 27th, this is backstory. We'll get up to speed today with the judge's order. But they filed this. While he has valid TPS status, he is not deportable today. Now, today, as of recording, is the 3rd. So his TPS status has expired as of today. Rather, Trump provides this short response to explain why it should be permitted to continue to detain Mr. Rojas now. Like, don't make us let him out because it's going to expire and then we'll never catch him again. They write, look, Section 1231A of the INA provides that when an alien is ordered removed, he must be removed from the United States within 90 days. This guy got a final order of removal from a judge. Of relevance here, TPS essentially freezes an alien's position within the immigration system. Thus, an alien may even be ordered removed while under TPS, though the order remains inexecutable so long as an alien remains a TPS beneficiary. So as long as TPS for you is active, you're safe. But upon the ending of Mr. Rojas's TPS status, which is here on April 2nd, his final order of removal would have been executable. An order. However, in the last month after Mr. Rojas was detained, he then filed a motion to reopen his removal order. And like the immigration lawyers in America are making so much money right now. I can't even imagine it. Because there's like now 350,000 people who are their clients. Could you imagine that? By the stroke of a pen. Biden lets in 10 million people, grants a bunch of them legal status. Then Trump says 350,000 of the TPS statuses are now hereby revoked. So if you're an immigration lawyer, you just got a surplus of 350,000 clients coming your way. It's crazy. It's how much money is being made by the lawyers right now. So this guy then went and got, all of his extended family, or maybe it's fentanyl money, or who knows what it is, but hired lawyers, then the immigration lawyers who are suing for these people to stay in our country, then is filing all these different challenges, right? Motion to reopen, now a TRO, very expensive legal work. So then the Fifth Circuit has already held that most challenges to a deportation order must not be filed not later than 30 days after the initial date. Therefore, Mr. Rojas should have filed his motion to reopen by October 10th. He's time barred. He waited too long. You can't just file whatever you want whenever you want. Show up to court or else. Now, despite the time requirement, just like you have a certain amount of time to appeal, right? You get convicted in a criminal case, you can't appeal your case 5 years later. You got like 14 days. Get your notice in. Mr. Rojas now uses this motion to reopen to further stall his deportation, paying thousands to the lawyers. Regardless, Trump will agree to keep him in detention and not deport him until a decision on the motion to reopen. Given that Rojas is likely deportable soon, Trump requests the court allow it to continue to detain Mr. Rojas since it believes that Mr. Rojas is a flight risk, right? He already did not come to court the last time. He's not going to come again. He got arrested. This is supported by the fact that he previously missed the immigration hearing where he was ordered removed, did not file any paperwork explaining the absence until 6 months later after he got picked up. And Trump believes that his prior failure to attend an immigration proceeding demonstrates he's a flight risk. And thus, detention at this time is proper. Don't make us let this guy go because we're never going to catch him again. So what did the judge do? Well, of course we know what the judge did. Judge Jose Rolando Olvera Jr. also looks like this, appointed by Joe Biden with no judicial experience before taking the bench at all, just got shoved in there as a political appointee. Great job. Amazing judge. Here, is what where are we at here? Here is what the judge wrote. The judge said the following. In the case of Adrian Gil Rojas, very short order from the judge. Judge Rolando Olvera explained. On this day came to be heard the petition for a writ of habeas corpus. Now the court holds that Adrian is a Venezuelan national with valid TPS. And he wrote it on the 2nd day of April. So it was like valid at the time of the writing, but was set to expire the next day. Okay. So what this judge has done is not even address that. Was wrongfully detained under 8 U.S. Code. And the court further holds that Trump produced no evidence that this person is a danger to the public at all, which I don't know why that's standard. Right? He's here in the country illegally. The standard is not if you're in the country illegally and you're a danger to the public. So they arrested him in New York, transferred him to Brownsville, Texas. Thus, this judge, Wild, wrote, it is hereby ordered that the government, Trump, you and me, America, at their expense, return this illegal to the city of his arrest in New York as soon as reasonably possible. Get him an airplane, first class, make it private if you have to, as soon as reasonably possible. It is further ordered that he be released on his own recognizance as soon as possible. Let him out of custody like now, with the recommendation that an ankle monitor be placed on him pending his immigration hearing. Yeah, right. He's going to cut it off and be gone with the wind. Ankle monitor. Okay, Judge. So Rolando Olvera, Jose Olvera releases Adrian Gil Rojas back into the country via judicial decree, and did it the day that his TPS was set to expire, and the judge couldn't say that anymore. Okay, that sentence is literally invalid today, according to the government. His TPS got revoked, not extended. So this is Judge Rolando Olvera, and he is in the Southern District of Texas, and he's got no judicial experience at all other than being a Democrat hack. So we now know the Democrats are going to now go visit the border. Bill Melugin reporting this, saying, shocking, they're going to go visit the southern border tomorrow. Maybe AOC will go in her white outfit and cry on a chain link fence, saying Benny Thompson will lead a delegation to the border. Amazing. Benny Thompson's one of the most incredible Democrats in there. Who's going? Thompson, Lou Correa, Tim Kennedy, Nellie Poo. They got a Democrat named Nellie Poo. That's funny. She's from New Jersey. Sarah Jacobs is going to be there. Now, here's what Bill Melugin pointed out. He said, I asked Benny Thompson to go down to the border back in 2022 when Joe Biden was in charge. And here's what Benny Thompson said back then.
Chairman, one question. In your opinion, is the border secure?
I have to go give a speech. Did you hear me?
I heard you. It's a quick question. Is the border secure?
Answers
Come on,
about
Benny.
the border, few and far between.
Benny, he has a hard time thinking or talking or speaking or walking, as you can see, kind of like Joe Biden did. So they're now going to go visit the border. And here is Mark Wayne Mullen, a senator who is trying to get a budget passed and trying to fund some solutions to the problem. Here's what he's explaining is coming next in the package.
Looks like we're going to be here all weekend. My wife and kids are not happy about that, but we've got to get this vote passed for the budget. Now, what does the budget actually do? It's the framework for us to move on to reconciliation. Reconciliation is where we're going to get all the DOGE cuts put in place. One thing that's very important to know, too, is that the Senate and the White House is working hand in hand. Leader Thune has an outstanding relationship with President Trump. We're in constant communications. I think we've had 2 or 3 meetings with the president this week. The most important thing that you need to understand, this isn't where we get the cuts. The cuts will come into reconciliation. You cannot get to reconciliation unless we pass a framework, and the framework is the budget. So this is just step 1 of a 2-step process. We are 100% working hand in hand with President Trump delivering his promises. I'll keep you more informed as we move forward, but stay tuned because we're going to have a long week.
All right, good. Get it done. We're looking forward to having some good progress from them, and hopefully some border security is in there. But as it stands, Judge Olvera is flying illegals back home to New York from Texas. And we'll keep our eye on this case. Thank you for subscribing and joining as we do. All right, and we got one final update, my friends, and this one is about the lib lawyers and Perkins Coie. Liberal lawyers are having a rough time. You remember this law firm called Perkins Coie? They were the ones that had hired Michael Sussman and Mark Elias back during the 2016 election. And from them, we got the whole fake Russian collusion hoax via Hillary Clinton. Tried to sell it to the FBI and all of those things. Well, it was a giant scam and scandal. So Trump, of course, canceled their contract. Said, we're not going to work with you anymore. Why would we do business as a federal government with a law firm that tried to take out the president? Obviously, you wouldn't. So an executive order came down. Perkins Coie sued everybody. And we're going to go through this filing from Trump, which is a motion to dismiss their lawsuit. A nice one here that we'll zoom in on. But this case is being held in front of Judge Beryl Howell. And Judge Beryl Howell is this woman here who has a long history of being a TDS anti-Trump judge. She was appointed by Obama. She oversaw grand juries for many Trump investigations. She breached Trump's attorney-client privilege with Evan Corcoran, his attorney. She was the judge who authorized search warrants to be conducted and was facilitating the investigations in Florida when she was in DC, right? Jack Smith was going and trying to get her to do his dirty business. Disgusting behavior. She was also the judge who was in this speech criticizing Trump as threatening American democracy, all of that type of stuff. But in this case, she has been making it a little bit more difficult than the Democrat lawyers would like. And something interesting has been happening here, because when the lawyers sued to try to stop Trump's executive order from going into action, she kind of split it. She says, okay, Trump is stopped from doing some things, but not all the things. And that didn't sit well with them. So in recent days, we've had a ton of these amicus briefs become filed in this matter. And you can see these are all liberal lawyers who are just freaking out because they know that this is not looking good for them. And Perkins Coie is like their BFF forever. So the ACLU, right, dropped one. Hey, can we come in and file something? Here's another one from law professors, right? All of them filing in here. We see some of Norm Eisen's people are here. Yeah, 363 law professors. What a bunch of idiots. Former DC bar presidents, morons, right? All submitting their amicus briefs. ACLU dropping their one in here as well. And many others. Now, Cato's in there. There's some other ones, but they're all filing. Here's one. Lawyers Defending American Democracy. I think that might be one of Norm Eisen's groups or someone else who's affiliated with him. So they're all filing like, save Perkins Coie. Don't cancel them because they're going to die if you do. Well, Trump filed a motion to dismiss. Things are looking good in this case because the judge has, even during oral arguments, had some skepticism about their arguments. But here is what they write. They say, listen, all right, Judge, it's time for you to dismiss this case brought by Perkins and all the libs. They write, look, on March 6th, not long ago, Trump issued an executive order that lays out the president's concerns about Perkins Coie. They screwed up election integrity. They tried to change a bunch of election rules, national security. They discriminate, they say, in their employment practices. And so we reviewed them. And we're not using our taxpayer funds to support unlawful or unsavory law firms. So then what they did is they sued. They submitted a 172 paragraph complaint and they created 9 separate claims when they sued Trump. But it's pretty straightforward. It's an executive order. They don't need to come up with all these claims. Trying to frame this as a sanction or something punitive is not realistic. And this lawsuit is going to risk muzzling the executive branch. Now, the executive order was very clear. It is reviewing 1, active security clearances. Section 3 is canceling any contracts. Section 4 is the Attorney General saying, are they violating civil rights laws? We're just looking at it. This is directing agencies to examining hiring, right, of anybody from Perkins Coie. So if like they try to leave the firm and come work for the government, no, we don't want to work with you. So The executive order is directing the agencies to do what they already should be doing. All we're doing is declining a contract right now. They're calling this like a constitutional, punitive, equal protection violation, all sorts of nonsense. He just canceled your contract. You can't even sue in DC. You should be suing in a contract court, like the Court of Federal Claims or something. The law does not support their claims, and so this court should dismiss this entire filing. Now, the complaint is breaking the rules on how they should even style this. And as we know, there's this rule called 12b-6. If you go to law school, they hammer that into your brain, saying that your case will be dismissed if it fails to state a claim. They have not stated a claim here. Now, they're raising these due process challenges and stuff, but it's void for vagueness. They also raise equal protection claims. But if they want to bring a claim like this, they got to show somebody's being treated differently. It's not here. So they raise all these claims. They raise First Amendment claims, right? And Perkins, they're trying to make it into a constitutional issue. It's not. They just got a contract canceled. But it violates our First Amendment. Your First Amendment right to have a contract with the feds? To succeed on a First Amendment claim, it's got to be First Amendment stuff. But nothing is fitting. First of all, they write, we're going to win. Section 1 of the executive order offers a brief factual explanation for why Perkins is terrible. As to its legal services, Section 1 explains that Perkins was the law firm that hired Fusion GPS. Yep, made the fake steel tape PP dossier. Crossed ethical lines. It's all public record. Now, as to Perkins and their hiring practices, they say that they racially discriminate against its own attorneys. They also got sued, Perkins, because the law firm's 1L diversity fellowship oh, wow. Man, white straight males, sorry, sucks. Membership in a group historically underrepresented was including students who identify as LGBTQ plus expialidocious. Everyone else got canned, racist. Now, only counts 2 and 3 actually challenge anything, but neither carries water. And so their claims are failing. The only supposed falsity in the complaint, which might be defamatory, is that Perkins racially discriminates. But the complaint cites to your practices and what you've done. You publicly announced that you signed the Mansfield rule. You said it, not us, that requires law firms to certify that women, lawyers of color, LGBTQ plus expialidocious, and all other lawyers with disabilities comprise at least 30% of the candidate pool. Yeah, so definitely no white dudes. In 2023, Perkins represented to Vault that it set formal measurable targets in imposing their racism. And they got policy manuals. They've got blatant race-based and sex-based discrimination. The government has every right to use our procurement power to discourage those practices. We're not going to work with racist law firms. That's ridiculous. Their other claims fare no better. There is no merit to their claim that this is void for vagueness. Here, the executive order is not a statute, so it doesn't apply, and it's not proscriptive like a criminal statute. This is a canceled contract, so they can't say this is like an invalid criminal law. No. And plaintiff has no plausible argument that the order is unconstitutionally vague. So the court should decline all of this. It's not a constitutional problem at all. The court should dismiss count 3 as well. Section 2 is also terrible. All these lawyers got together, couldn't even write a good complaint. Plaintiff, the lawyers, appear to challenge the aspect of the executive order. They say it's ultra-virus. Trump doesn't have the power to do it. They say it violates due process. It violates Perkins' First Amendment free speech or free association. Now, the same should be true with Trump's executive orders as others. And the entire Steele dossier involves multiple falsehoods. Trump meets the standard, saying these people are not legitimate. John Durham pointed it out. The Durham report references Perkins Coie 40 times and details its role. They were senior counsel to Hillary. They wrote the Steele dossier. All of this means Trump can choose not to work with them. Their other claims must also fail. Any individual employee of Perkins with a security clearance will receive due process post deprivation, and they can maintain their security clearances as permissible. So we're going to, like if they're working on a case, they can keep their clearance. But Section 3 is also going to fail. It is our privilege to decide with whom we work. Trump is clearly authorized to manage their contracts, right? Trump can decide who to work with. There is no equal protection problem here. And their procedural due process claim is meritless as well. To establish standing, they must actually suffer an injury. But this is a contract dispute. There is no imminent conjectural injury here that is happening other than they got canceled. Plaintiff complains that its clients are withdrawing. We're losing money. They don't want to work with us. And they say that there's not adequate process for us to maintain these contracts, but they never say that they're in the middle of currently contracting or bidding for contracts. But even if they were, they don't have a right to keep that contract. So then they raise First Amendment claims, like throwing everything they can. According to their First Amendment claim, they call it retaliation. They say you're discriminating against us based on viewpoint. The fact that actions are punishable under civil rights law does not mean that they have a claim against us here. The fact that a funding program supports one point of view does not establish viewpoint discrimination. So Trump can move the money around. It doesn't mean he's challenging your free speech. Then they say this is a right to counsel problem. But they give us no examples of that at all. The closest they get, they say one of our clients is now considering retention of an alternate law firm. But that's the point. Unless the DOJ investigation somehow implicates a government contract, which they're not even alleging, there's nothing to say about that. It's not a civil rights claim, and any supposed injury is not traceable to Trump. So it's not a civil rights problem as well. Now, even assuming they engaged in some protective conduct, they can't show a link that Trump's order is violating their civil rights. And they're not entitled to federal hiring either. So just a methodical, point-by-point refutation in the motion to dismiss. They say, finally, they say this violates their client's right to counsel, but we're not going to give them unfettered access either. So the court should dismiss the claim submitted here by Richard Lawson against the lib lawyers. And we'll see what they say in response. Of course, they'll have an opportunity to respond to this, say, don't dismiss it. And there's a bunch of them all piling in. So it will go over to Judge Beryl Howell, and we'll see what she says about it at the end. But we also had articles of impeachment get filed, courtesy of Representative Andy Ogles. And I wanted to play this video for you, man. And if you have, any problems with like flashy lights or anything like that, get prepared, because there's some serious congressional editing happening in this video.
Hey guys, Congressman Andy Ogles here. We just filmed Restoring the Republic, episode 35. You need to check that out. Some hot clips and great information. But look, so I have the information on the judges, the woke activist judges that are really working against the president, against the Constitution. So you had a Democrat, McGovern, who in committee railed against me, talking about how the poster points out the fact that these judges are, quite frankly, weaponized against the American people. So with that, and he asked that I take the poster down. So here's the poster. You see it, it's in front of my flag. I am taking the poster down. But that being said, I want to point out that there are more activist judges who are working against the American people, against the president, who are in violation of the Constitution. Our founding fathers warned us against these type of judges. So here you are. These folks are not following their oath. They're working against the Constitution. They're working against you. Kudos to Elon Musk. Kudos to Doge. We're going to fix this. The fight isn't over. We're going to keep fighting. We're going to keep working. We're going to hold these judges accountable. Whether it's impeachment, whether it's censure, whether it's funding, we're going to do our jobs. We're going to fight. We're going to fight. We're going to keep on fighting.
All right. So, man, interesting. So we appreciate the message, and it's a very interesting style of editing there. Very hard-hitting. Maybe Gen Z is going to be into it. Very nice to see him explaining the pressure that is going to be put on these judges. And these are many of the judges that we've covered here. You can see several of them. There's Amir Ali from Ontario. There's Chung. I think he's from Maryland. And the list goes on and on. So good stuff there from Representative Andy Ogles. And we're going to see more from him, no doubt about it. So good stuff there, my friends. All right, if you're just joining us, quick recap on what we covered today. Judge Boasberg, his case is in the Supreme Court of the United States. Trump submitted their final reply in support of the Supreme Court accepting the case and vacating his lower level orders. Good filing there, waiting for SCOTUS to do something about it. Then we went through the hearing that took place today, courtesy of Margot Cleveland, did a great job reporting on what took place inside. And Judge Boasberg, according to Margot and according to Julie Kelly, have explained that it seems like he might be issuing a ruling on contempt, or holding Trump in contempt. So that whole thing might get very spicy soon. Then we talked about Judge Rolando. Jose ordered an illegal to be released from Texas, who is set to be deported, and ordered him to get a plane ticket back to New York so he can hang out there with Mayor Adams. Read through the filings and explained what's happening. This guy did file a petition for a writ of habeas corpus in Texas. So maybe Boasberg should get the memo that they can do that and get rid of that case in D.C. Then we talked about Judge Beryl Howell, and she just got a motion to dismiss from President Trump that is asking that the Perkins Coie lawsuit against the administration, that it would force them back into the government, be dismissed, and we hope she rules appropriately. But now, my friends, it's time to hear from you. And I hope you're having a beautiful day and you're feeling amazing and you're ready for Friday, which is coming tomorrow. We're looking forward to it, but it's not here yet. And I appreciate you sending in these donos and supporting our work here. Thank you for becoming membos, and thank you for the super chats and for the fun and the friendship. It's great to be here with you. Let's see who's joining us. And we got Donut John clipping for us today. Thank you, gentlemen. We got some new membos. Whoa. All right, look who's coming in. Got a bunch of new membos, man. Hey, this is exciting. Okay, membos, we'll see you tomorrow on the members only morning stream. It's going to be 12 noon Eastern tomorrow, and it's going to be Friday. We're excited about it. What's going on? Whoop, whoop. It's almost Friday. Snoopy's dancing for us. We got Dory Burns. What's up, Dory? Thank you, Dory, and thank you, Bradley Ashley, for becoming membos. We had a great members-only stream, talked all tariff stuff, and it was good. Sheila Pooh says, deport Judge Jeb and Judge Olvera. Yeah, I think they're both citizens, but I don't know. They don't really apply the rules at all anymore, so maybe there's an argument there. Rick D says, just wow, this is BS. The perp is a victim. Sharing this link from Bloomington. Police chief is now calling the Tesla vandal a victim because people are saying mean things about her online. Thank you, Rick. Hunter, what's up? Says, I'm upset that YouTube didn't notify me and had to find it. YouTube. Yeah, YouTube does that because they hate us. Thank you, Hunter, for being here for 15 months as a member. We appreciate that. Coming up on 2 babies. Christopher Hammonds. When is all this going to end? Well, I would say July 4th. A lot of this is going to start to resolve because TROs, let's say, TROs plus injunctions, plus appeals, plus all that stuff, 90 days for like the preliminary stuff, then another 90 maybe for appeals. So 6 months, I think 6 months is about, I think we're going to start to see a conclusion of this. Hey, it's the Munkets is in the house. I hope sooner, though. Hey, it's the Munkets. Thank you, Tony Hay, for bringing in 10 membos. What's going on? Kevin G is here. We got Bro, he is here. Justice, Ken Phillips, Mama Suri, Mrs. Hayes, Chinny Win, Zach Bennett, Adam M, and Pat Hacker, gifted membos, courtesy of Tony Hay Munkets. Thank you, Tony Hay, for bringing in 10 new membo friends. Gimme More is here. More Here is bringing in 10 new friends. What's up, More Here? Thank you for this, too. Willie D, what's up? Tanya C is here. We got Mr. E409. What's up, Mick Kevin? We got Eyes Dillagaff. What's going on? Blue Nose Bob. We got Bruce Little. NY Renal, also on locals. M. Nagem. And Danny S. Gifted membos, courtesy of More Here, bringing in More Here. Thank you, More Here, for doing that. Hey, Clark Blount. 10 membos from Clark. This is awesome. What's up, Clark? Thank you for bringing in Bratty Brat. Christy, Kelly Ann Minnis. We got Ungoliant, Caleb Hokett. We got Sergeant Schultz, Bobby McKenzie. We got Hello Kidden. Pooty Poot is here. Pootie Poop, just like Nelly Poo from New Jersey. Do you guys know each other? What's up? David Chamberlain also gifted a membo. And just Rhonda, our purveyor of fine emojis, also on YouTube next door, shouting out our new membos. Hey, Patrick. What a nice dono. Thank you, Patrick. Man, this will help in our Trump Gold Card Fund. Hey, thank you for everything you do every day. Your show helps the average American understand the law in layman's terms. Keep up the fight. Patrick, Kildia, we appreciate you. Thank you for the nice dono. We are going to keep it up. I'm really glad that you're here. Thank you for supporting our work and being with us on the journey. Yeah, it's what we're doing. We're trying to have a conversation about what's happening here, and we're learning a lot in the process. Tony Hay, bringing in 10 membos. Thank you, Tony Hay. Look at this. Sean of Time, TJP, Commentarian. We got Jay Alberto, Don Hastings. We got Zeb Smith, Metal Jake. We got Scott Vincent and MMO Mox, along with Charles R. Gifted membos, courtesy of Tony Hay Munkets in the house. Sheila Poo, look at all these membos. Man, I'm so grateful. Sheila, bringing in Bob's mom, Duncan Freeman, Michael Lumovich. We got Primo Avatar, William Key. What's up? Binford Bear, Kay Stanford, RDB in the house, Another Kid, and Sarah D. Gifted membos, courtesy of Sheila Poo and a dono from Sheila. Sheila, you rock. Says, in my opinion, these rogue judges demonstrate exactly why lifetime appointments are bad. Make it a term of 8 years. Then they would have to be reappointed and undergo recertification by the Senate so we can weed out the rogues. You know, that is an interesting idea, Sheila. Like, rather than people try to, what do you do about the judges? Like, judges are always a problem. And they have been a problem in our country forever, which is why the judiciary was pretty much a weak branch. And they have to rely on their legitimacy and credibility to exist, essentially. And now that they don't really care, right? They kind of feel like they've got more power than they really do. In terms of the thing with voting, right? Then you get into a situation like with Brad Schimmel, and then tons of money goes into it. But reappointment might be a better solution. Then you would start to time these things, right? And you'd watch huge swaths of judges be up for reappointment. Yeah, it's interesting. Interesting idea. Have to think that through. Maybe longer. So like 6 years for senators. So maybe you give them like 12 years and they come back up. Interesting idea, Sheila. Good one. Grim Wolf says, with TVA being designated foreign enemies, Tren de Aragua, can those providing aid to them be considered as giving aid and comfort to our enemies, i.e. treason? Yeah, you mean like Judge Boasberg? For ordering them back into the country? Great question, Grim. What's up, Jennifer says, another shameless plug to remind your awesome viewers, they are awesome, to please join Richard and Davey at Off Label Podcast tonight after the show on YouTube and Rumble. So definitely check them out. Off Label Podcast. Richard and Davey, Voice of the People comes by. And Jennifer, I hope that they have an amazing stream. And if you're a part of it, you too. What's up? Martro says, can you ask Rob about Rule 65C? This is the injunction bond rule. So yeah, what about it specifically? So what's happened is Trump has been asking that they comply with it. So this is the injunction bond rule. So for example, like, let's say you get a speeding ticket, cost you $500. You go to a trial, you lose it. You want to appeal the speeding ticket. You got to post a $500 bond while the case is processing. That secures in the event of a loss. Then if you lose the appeal, you forfeit the $500. If you win the appeal, you get the $500 back. But since you lost the lower level hearing and you're appealing, you have to post a bond. Same concept here. You're going to ask that the government dole out $2 billion to all of your NGO hacks. Well, how about you put up $2 billion as security? Rule 65C says that it's mandatory in order for the injunction to go out. They've got to post a bond. Problem has been that the judges just issue a nominal bond, which means it's like $100, which, as we've seen, is easy for them to put up. But so it's a procedural speed bump that the judges are just speeding over. Tony Hay, Whoa, you can gift membos on Rumble now? I did not even know that. How about that? Tony Hay gifted a membo to Blue Bunny 420. Amazing. Welcome, Blue Bunny. Michelle is here. Says, is it possible Tren de Aragua doesn't want members to file their own appeal because the gangbangers might snitch? If so, are the lawyers acting on behalf of the gang or the client? Is that ethical? Yeah, so that's a great question. Yeah, I mean, gangbangers get lawyers too. No doubt about it. And I don't know if they're worried that they would snitch per se, because they're not really being, like criminally prosecuted in these hearings. They're deportation hearings. And the habeas petitions, I mean, there's no real penalty if they lose, and they're not going to be compelled. I mean, it might delay their deportation, and they do get held in government custody for a while. So like if there's somebody that they think might get interrogated or might be a witness to another crime or might be an asset for the government, they may want that person deported, right? So they wouldn't support them filing a petition for habeas that might hold them in government custody for a longer length of time. But also, if they're successful, then they get another gangbanger in America. So if they lose, they don't really lose because they're going to get deported anyways. But if they win, one of their people goes free. Deplorable number 1 says, I really wish the government's attorney would be like, you're on it. With all due respect, who do you think you are, Judge? Yeah, Your Honor, thank you for that comment. And I understood what you said there. But my response, quite simply, is, first of all, who the hell do you think you are? He's the President of the United States. This matter is closed. Yeah, that's pretty much how I'd like to approach it. Chubby says, I love the DOJ suggestion of using bureaucracy against Boasberg. That was just awesome. Yeah, no, we're going to get right to it. We're going to get it done immediately. Just going to have to send my carrier pigeon to the airplane, see if it can catch it. Mock Schnell. What's up, Mock Schnell? 20 membos coming in. That's a lot, Mock Schnell. What's up? Truth Matters is here. Lying dog-faced pony soldier just became a membo. D herself. We got one Jump Bob. What's up, CL? Norm G's here. We got Mendy Harris, Sean A, Joshua Knows It All. Somebody else is here. MM, what's up? Cody Mamita. Cody's Mamita in the house. What's up, Caleb Crow? Michael Rentier. We got TTS Warhammer 40K, which I heard is a pretty cool game, but I haven't played it. Lee, what's up? Peter Peraskivi in the house. We got Darjair 69, Mike Cabral, and Grouchy Mama Bear in the house, courtesy of Mock Schnell, bringing in 20 new membos. Hey, it's Bruce Rice Baby, bringing in Tony Hay Munkets on your behalf. Good to see you, my friend. What a nice dono, Bruce. Thank you for that. On behalf of Tony Hay Munkets, shout out to Tony Hay, bringing in new membos. Hey, Just Rhonda. Just Rhonda is on YouTube next door. She's also our purveyor of fine emojis here. All these beautiful emojis like this one and this one, courtesy of Just Rhonda. We're grateful. Hey, there's no way I could listen to these motions without Rob reading each one. Each one is like a mini one-man comedy skit, and I'm here for it. Hey, me too. Good to see you, Just Rhonda. We're here. Yeah, it's funny, man. It's funny. They're like little comedy skits. I don't even write them. They just write themselves. We're living in bizarro land. Thank you, Just Rhonda. Subscribe to Rhonda's channel. One Deplorable says, at the very least, they should have them in front of the Congress, tying them up so they're not even hearing these cases. Just keep them busy. Well, yeah, so I don't know exactly in what context you're referencing here, but have them in front of Congress, tying them up. So like, was it Mike Lee? Oh, okay, I see. So yeah, bring the judges in front of Congress for impeachment proceedings or for questioning so that they're not in their courtrooms injunctioning the entire nation. Good comment. Yeah, what's up, Annie? Annie Bielecki says, hey, listening to you from Melbourne, Australia. Look forward to each new episode. And Annie Bielecki, thank you for that. That's awesome. And it reminds me, I have a friend that I met at AmFest who I need to reach out to from Australia. Yeah, that's a good reminder. Thank you for that, Ann. And thanks for checking out the show from Australia. Always blows my mind when it's like, that's on the other side of the world. Very cool. Thank you for saying hi. Pinochet's helicopter tours, the most exciting helicopter ride you've ever been on, says, did you see that John Roberts in 2012 stayed with Norm Eisen to work out Europe and the U.S. rule of law? John Roberts is a globalist conspiracy. I did see that. I have not looked into that in further detail. I saw that in passing today. I think from Mike Benz, I think is where I saw that. But was that from Norm Eisen making that statement? I got to listen to it. I think that's where it came from. I think Norm Eisen was like bragging at a podcast or something. But yeah, wild. And that's a problem. Doan says, suddenly I have no doubt Boasberg knew the Carter Page FISA warrant that he issued and then renewed 4 times was as crooked as a dog's hind leg. From Doan. I think you're right. Yeah, that guy is not on Team Trump in any way, sense, or form. Doan says, I think Jeb is a party to John Roberts' memory lapses. Oh, you think so? Jeb. And the Chief Justice. Yeah, I don't know. I'm sure they all hang out together. Maybe they traveled to the Czech Republic. Maggie B. Hey, thank you, Maggie. Says, thank you, Robert, for all your hard work. It is very educational, helps us to understand constitutional matters and our current situation. And God bless you. God bless you, Maggie. Thank you for that. Thank you, Shane. You too, my friend. Really nice, Maggie. It's an honor. It's a privilege. I really enjoy our time together. So it's my pleasure. Thank you. Rob says, send this guy to the judge's house. Yeah, fly him back to D.C., okay? He can go running around the park with Judge Boasberg. Shane saying, if you have thumbs that work, like this video, share this video, subscribe to the channel, hit the notification bell, and select all so you never miss a thing. Rob on Rumble says, Trump should say, I will allow all the illegals to stay and take credit for keeping them here. They will then all vote for me. Democrats will be like, get him out of here. Trump can't have credit for it. Get him out. From Rob. Could be a possibility. Acid Burn says, 40,000 Chinese crossed the border. Where are they now? I don't know. Eric Swalwell's house, probably. Londo, that politician is a filthy liar, setting up failure for the cuts. The cuts must be part of the budget to pass with less than 60 votes. They really anger me when they play this slimy game. Trump needs to slam him for it. Yeah. Congress gets very sneaky, especially at these times. Like, we're going to be here all weekend. Going to have to bring my baby too. But we're doing it for you, America. Like, oh, give me a break. What are you doing there? What's Up Deplorable says, these judges even have any prior legal experience? A lot of them do not. A lot of them have none. And when you start looking into it, it's pretty shocking. Hey, Mr. Magic Man. And that's, by the way, across the board. That's in your local state, too. It's not just these political people. A lot of judges are just not really qualified. Mr. Magic Man says, instead of Congress threatening to oust these judges in the hopes that Roberts will rein in his judiciary, why don't they just do it and tell Roberts to pound sand? Well, that's because they're Congress, Mr. Magic Man. And really the only capability that they have is to talk and on rare occasion send letters. So I don't know. The next step will probably be another letter, maybe. Maybe Jim Jordan will write this one again. What's up? Delay is obvious. Says, I can't stop hearing habeas porpoise. Well, it is a nice looking porpoise. That is for sure. I can see why it's hard to get out of your mind. Lady Ice says, okay, what the heck? Really? Tim Pool posted saying CIA classified doc reported aliens attacked a Russian troop. What? That's crazy. Man, Tim has the best stories, doesn't he? Shout out to Tim Pool. Run Mead. In the end, this whole saga will be a case long used in law schools as an example of what happens when poorly thought out cases are presented. Oh, the billable hours. Yeah. Gosh, I was thinking the same thing. I'm like, did they give this to like first year law school students and like just come up with as many constitutional claims as you can? They're like, I know. First Amendment free association. Like, what? Oh yeah, that's great. Yeah, do that. Hey, Sharpie guy. There are so many reasons for the House to remove these judges, especially Boasberg, under the good behavior constitutionality standard, and it's now or never. So many crooks losing their cash flow, right? Rob, please encourage watchers to contact their representatives. Please. Oh, please. Well, you heard the man, Sharpie guy, encouraging you to do it. And we got Andy Biggs in Arizona. We're doing our part. Hey, this old guy says, Rob, Rob, given a little time, we got you valid creds. Oh my gosh, I'm now credentialed media. Perfect. I was asking for some help on this morning. I said, I need to get a valid number, a license. It says also, I got valid creds now, so I'm going to the White House. So locals help me get one. It's official now. All right, Caroline, we're coming to see you. Hey, says Rob, given a little time, we got you valid creds. Thank you. That was fast. I asked for it this morning. You guys got it already. Also, if the Dems want, I can recommend a couple of really good restaurants in Ciudad Juarez if they don't mind walking across the international bridge to get there while they're at the border in El Paso. Tell them to be sure they stay hydrated while they are at dinner. Yeah, stay hydrated and wear some body armor too. That'd be a good idea too. It's official, baby. It's valid through October 2028, and then I got to renew. All right, thank you for that, this old guy. I'm excited. It's going to be fun. Here's my new media badge. Yep, read it and weep. What's going on? Hey, our Darius Mist Dancer. Hey, welcome aboard, Darius. We'll see you tomorrow on the members-only morning stream, 12 noon Eastern. Mark Nielsen, 13 months as a memo, says, if part of a class action, how can I file in Texas? Thank you, Rob. Oh, I see what you're, yeah, okay. I think I see what you're asking. 13 months as a memo. Thank you, Mark, for that. So in other words, I don't know if that person was subject to the proclamation. Okay. So that other person who got the flight back to New York, I don't think he was Tren de Aragua. So he's not certified as a class because he's not under the proclamation, is my understanding. Great question though. Doan says Perkins Coie is acting like the mob boss in Godfather 2, who forced the shop owner to hire his worthless nephew and fire Vito Corleone. You know, that ended well from Doan. Yeah, they're dragging all their friends in, and their friends, I don't know what they're doing, man. It's not going to work out for them. So, but many of them are already basically excommunicado. They're like Norm Eisen's allies and stuff. Hey, the Silverback. Great to see you. The Silverback is here. Thank you, the Silverback, for joining up as a supporter. We'll see you in the morning tomorrow. Deplorable says, hey, watched you on Steven's show yesterday. Good show. Yeah, my friend. So that got published, I think yesterday as we were live. Stephen Gardner. If you're not already following Stephen Gardner, he does great work. And he did even greater work yesterday when I was on the show. And we had a great conversation about the judges. And let's see. Oh yeah, this one. We talked about Tish too. Okay, so I'm going to share this link with you, my friends, and go check this one out. Here was your boy with Stephen Gardner yesterday, or not yesterday. I don't know when this was, but we did this and it was a ton of fun. So I'm going to share this link with you. Head on over to Stephen's channel. There's a nice pause of your boy, but we talked a lot about a bunch of stuff and it was great fun. So go check it out at Stephen Gardner's channel. He's got 1.93 million subs over there. And tell him we said hello. Tell him the Watcher fam says hello over there on the Stephen Gardner channel. So I'm dropping that in the chats. If you're looking for something you want to go watch and check out right now. And say hello to Stephen for us all. All right, so my friends, thank you for sending those donos in. And Robin Kirkland, thank you for becoming a supporter. Knox says, hey, happy Thursday, all. It would have been really cool if they filed a habeas corpus in Corpus Christi district. And then nobody's going to know what to do. I'm going to court for habeas corpus in Corpus Christi. The hell did you just call me? You're fired. Get out of my office. No, be careful with that one, Knox. All right, so Stephen Gardner is not a gardener, okay? He's an intelligent person who talks, not that gardeners are not intelligent people, but we talked politics. We didn't talk about how I can't grow anything ever because Mother Nature hates me. Let's say hello to our friends on X and see who's joining us over there before we wrap it up and go over to locals, watchingthewatchers.locals.com. What's up? George is here, says this nonsense investigation into the plane will all be dropped when the DC judges are eliminated from the TROs. So, yeah, it kind of depends. It's like, if the Supreme Court comes back down, we're at the Supreme Court on this. If they say, you don't have jurisdiction, this is a habeas claim, dismiss this case, they can file in Texas, something like that would get rid of it. But if the judges are like, well, here's the new standard and go down and rectify it and send it back down, then it might stick around. Yeah. Hey, I'm late, Jody. Have to hit the rewind. Good to see you, Jody. Kim, we can't believe what they did. Julie was on the War Room today, and you should have her on to explain. We love Julie. Yeah, she's in D.C. We don't know for how long, though. What's going on? We love Julie Kelly. Free Thinking Latina says, thought I'd try your name in Spanish with the dramatic puts hands on the foreheads, rolling the R's. Well, I can't roll my R's. Roberto! Hola, mis amigos hermosos. Hello, my beautiful friends from Free Thinking Latina. I can't roll my R's, which has always been a real sore spot for me in Spanish class for 6 years. What's your name, Robert? My Spanish teacher. Say it like you should. I can't. Why not? Because, I don't know. I guess I'm white or something. I don't know. I can't do it. I don't want to talk about it. Thank you, Free Thinking Latina, for bringing it up. Hey, what's up, Elliot? Alien Enemies Act plaintiffs point to Washington's use of predatory incursion in wartime letters. Washington's latter use of predatory incursion in front of Congress seems to bear on the scope of the term. But I haven't seen that 1796 speech cited in litigation from Elliot, Doc Master Elliot, and Poet Master Elliot, who is digging into the Jack Smith stuff. Make sure you're giving Elliot a follow on X. Yeah. It is a predatory incursion. It's not a military invasion. They know what that word means. They could have just put it in there if that's what it meant. But that's not what it means. So, good stuff. And my friends, what a beautiful stream it has been. I'd encourage you, go check out the Stephen Gardner conversation. We talked about Letitia James. We talked about her fraud, her mortgage fraud, and what a corrupt and stinky, shoeless person she is, stinking up the entire court buildings in New York. It was a ton of fun. Check out Elliot's Substack. Go over, check out the Off-Label podcast. There's a lot of stuff to check out. It's kind of like homework, so we appreciate it. But my friends, okay, we're going to leave it there on the day. We're going over to locals. We're going to debrief, hang out for a bit. Of course, we're coming back tomorrow before we log off on the evening. Let's say hello to our mods and meme smiths. K-Bean, Donut, mind me. We got Carrie B, playing hooky, Dog Digger, and Janek modding the fort down for us. Elliot, Doc Master, Just Rhonda, Purveyor of Fine Emojis, Geegum Geegum, Meegum, Meme Smith Extraordinaire, and we appreciate everybody who helps keep this train on the tracks here at the show. We will unplug for today. We're coming back tomorrow. It's going to be a beautiful Friday. We're excited about it. Can't wait to see you here. In order to do it appropriately, we are going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.